The National Assembly has passed the General Intelligence Laws Amendment Bill with the support of all parties except one. Now, the bill has been criticised by some analysts who say that some of the definitions of national security, among others, are way too broad, while some say that it may give the Inspector General of Intelligence strengthened oversight. So let's break it down for you and tell you why this is important. We speak to Heidi Swart, Research Coordinator at Intelwatch. Heidi, thank you so much for your time this afternoon, and I'm hoping just at the end of the conversation, our viewers can understand the importance of this particular step. But let's talk about the significance of where things are now, particularly in relation to this bill.
Great. Thank you so much for the invite. Much appreciated. So the big hoo-ha about the bill at the very beginning, when it was first, the first version was released sort of in the middle of last year, was the fact that it allowed for what called for the mandatory security vetting of non-profit organizations as well as religious institutions. So basically, it would have given our intelligence services the ability to put our NGOs and churches under surveillance, and perhaps we feared even shut them down if they were found to be a national security threat. So we're very happy that after a big effort from the side of civil society, that these provisions to have, nonprofits and churches vetted have been dropped, and that is a major win for us. But there are some issues in the bill that we are still very concerned about that we think haven't been adequately addressed at all. So, for example, the bulk interception of communications. That is when the government scans everybody's communications, basically, in order to see if they can locate criminals or terrorists. That's explaining it very crudely.
And Heidi, Pardon me, before you continue there, because it was one of the questions, this new bulk interception center, what exactly is this information that they will be intercepting here? Because I'm sure a lot of people are wondering, could it be phone calls? Could it be texts? Could it be conversations I'm having?
So this is the thing. We don't exactly know what technology the State Security Agency has at the moment, right? But bulk interception technology, we have a company in South Africa called Vastec that makes this type of technology, and it's capable of collecting the communications content, so that's the actual phone calls and emails, etc., of millions of people simultaneously. It's also capable of doing retrospectively looking at searching conversations using artificial intelligence, using search terms. So in other words, the idea of bulk intelligence is to be able to suck up everybody's data, everybody's conversations, etc., and then go and look in that massive data using technology to find patterns and to find people's personal information and communications. The rationale being perhaps they are terrorists or criminals, etc. So that is how powerful bulk interception can be. So the problem with this law right now is that it is widely written. So even if our government right now is not actually busy, recording everyone's conversations, it doesn't mean that they can't do that in future. And they have introduced a judge to oversee bulk interceptions, which is a great improvement. But the law is still far too vague about what bulk interception entails, what it doesn't entail, and what the minimum requirements are in the technology and itself to protect ordinary South Africans from being caught up in that surveillance dragnet.
So what does it mean then? Because further, it says that if it becomes necessary to engage in surveillance, for example, of a citizen of the Republic, whether they are in the Republic or outside, they can now also notify the person within 15 days. Is it clear? When does this become necessary?
So here's the thing. The whole point of bulk surveillance is sort of scanning communications perpetually to hear what people in other countries are saying, is to see if you can locate criminals potentially and then target them, or terrorists potentially and then target those people. So the whole point of bulk interception is to ultimately target individuals or smaller groups of people who you think are a danger. The issue with that, though, is that while the National Communication Center and the bulk surveillance is only meant for foreign communications. So in other words, people who are not South African, right? And not for communications in South Africa. So while it's only meant for that, it can be used to intercept communications from people in South Africa. Yeah. The technology can be used for that. So the idea here is that if the State Security Agency decide they're going to use the National Communications Center to actually surveil a South African person or someone in South Africa, then they have to go through our existing court processes, the same as the police now must do, or the Financial Intelligence Center must do. If they want to target an individual in South Africa, they have to go through a special judge. It's called a RICA judge. And they must also, in terms of the new amendments to our interception laws, which is a separate piece of legislation, by the way, they have to notify those people. So basically, all that this section says is that if the SSA uses bulk communications and they eventually get to an individual they want to track, then they have to obey South Africa's already existing interception laws that the police and everyone else has to follow. So
how much coordination is there, though, between this particular piece of legislation as well as the RICA amendment bill? Are they speaking to one another?
Oh, you see, that's the whole problem. We advocated initially for RICA to apply as is to bulk communications with a few extra tweaks, right? Because there's so much more data involved in bulk communications. So the point of RICA is the Regulation of Interception and the Provision of Communications-Related Information Act. The point of that act is to make it illegal to intercept any person's communications unless it's for specific purposes as laid out in RICA. And that has to do with crime and security threats, etc. So that is that law is very clear. And in actual fact, the State Security Agency, they already had to comply with that law. They were already applying to the RICA judge for targeted interception. So repeating it in this law is not only sort of going overboard, it's also unnecessary, and frankly, it's also confusing. Because now, which law do you apply then? Does this mean that are we going to change RICA now? Does the SSA, are they a special class of people who can, for interception? So it's very difficult. The way it's written makes it much more difficult to interpret the law, and really, it is unnecessary to in the end to add that into this bill.
And it'll be interesting how all of it, unfolds now, especially given the fact that there's still the National Council of Provinces. But let's see what becomes the next step. Thank you so much for just giving us some insights into, this particular development. How does it apply to South Africans? But also, what are we seeing unfold before our eyes? And I hope we speak again as the story continues to unfold. Heidi, I do appreciate your time. That was Heidi Swart, Research Coordinator at Intelwatch.